All right, you're still under oath, state.
Your Honor, at this time, state would like to offer into evidence 36A as pursuant to the court order.
All right, defense, any objections? All right, then states 36A is admitted.
May I have permission to publish?
Yes.
Thank you, Your Honor.
Yes, it's next door, 8615 Northway. I just, there was a car that passed by and started shooting to the next door. Okay. One second, I have one right here. So that's the silver Chevy sedan? Silver Chevy sedan? No, it wasn't a Chevy sedan, it was like a burgundy kind of car. Like a burgundy car? Yeah. And there was another vehicle was involved, correct? It was, I don't know, apparently they were like searching each other or they passed by and they shoot and then the other car just moved from the house to some other place, I guess. Okay, so you followed the other. Versus the SUV versus, and you didn't see the silver sedan, correct? The silver sedan, I don't see that. Because, well, it was parked in front of the house or something. I just saw the other one that it was over at the phone and I just hear the pop, 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 and I was like, what the hell is going on? When I checked, there was this SUV. It was kind of a Pontiac SUV, kind of weird, on the back part. And did you see the burgundy SUV specifically shooting? No, I didn't see it. I just see it sitting up. Okay. So you just heard the shoot? Yeah. There was a gray car in the front right there, right? Hey, this is my house, and if somebody's shooting next door, I have to, report it. No, not that, no. No, my husband gave me a look, like a so I'm looking at it, okay, but this is next door. Exactly. No, yes, we do have officers in route right now. I just advise you to lock the door inside the house. I believe it's something happened on your day. I don't want to see. Okay. I don't want. Okay. My husband he just arrived with my name is whatever. I'm sorry. Get inside, Andrea, and stay away from the door. First name, Deborah. Baba. Deborah, DEBORAH. Okay. All right, sorry. You didn't see any subject or anything like that? There was a black guy in there, but there's a bunch of people always, like moving around that house. So, okay, no. And was it inside of the? I didn't know. I didn't know, what happened. I just so the 8615 Northway, is that where the background is? Well, it's at the street where my house is. Okay, so it's the house next door, yeah. Next door is at the house, the left or the right? To the left. If I'm looking at the house? If you're looking in the front, it's gonna be the right.
And Deborah, is that your voice?
Yes.
So we pass the witness, Your Honor.
Defense. All right, is this witness excused or subject for recall?
Subject to recall from the state, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone except for attorneys for the state or the defense. And you're not allowed to view anything concerning this case. Do you understand?
Yes.
All right, thank you. You may step down. State, call your next witness.
Yes, Your Honor, state calls Andrew Kadari.
All right. If you have a seat here, please. If you can raise your right hand for me, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Andrew Kodiar. I'm a fingerprint examiner for the Bear County Sheriff's Office.
All right, state.
Good afternoon, Andrew. What is your area of expertise?
I am a fingerprint examiner for Central Records over at Bear County.
Okay, and do you have any certifications?
I do.
And can you tell us what those certifications are?
It consists of taking a fingerprint class for 5 days for the whole week for 2 weeks, after which you are given a certificate. And then after that, it's just another 2 to 3 weeks of on-the-job training.
And to have your fingerprints certified, what does that mean?
Finding the right characteristics that classify a person.
Okay. And can you talk to us a little bit about the process that you go through to determine whether you have met those characteristics?
We have to find at least 12 points before we determine if the person is really the person that we're looking at. Also looking for anything such as whorls, loops, and arches.
I see. Okay. And how do you then compare fingerprints?
For example, for court appearances, we compare the prints that we have on file to the ones that the defense has with them in their judgment packet.
Gotcha. And how many comparisons have you made?
I mean, today or just in general?
In general.
In a ballpark, I would say, as far as court appearances, I would say roughly around 10, 12.
Gotcha. So let's start with just the basics. What is a fingerprint?
Characteristics that classify or that help us classify a person.
And does anybody have the same fingerprint as somebody else?
No, they do not.
Okay. And when you actually, and I guess let me talk about the actual print of the finger. What is that? Let me rephrase the question. On what medium do you take fingerprints on?
Medium such as, what do you mean?
What do you use to put the fingerprints on?
We personally don't administer the fingerprints, booking does. We're given the prints, for example, to create a new SID, or like I mentioned earlier, to determine if the person is really the person we're looking for.
Gotcha. Okay, and the actual fingerprint, is that an impression that's formed by the finger?
Correct.
Okay. And is there a standard way that a fingerprint comparison is done?
Standard is usually once we're done checking for warrants and mug shots, we check on APHIS to make sure the prints on the back of the booking slip match the ones on APHIS.
Okay, and that's for a booking slip. And I guess what I'm more asking for is the process that you use to take the fingerprints. Is that a widely accepted process?
Correct.
Okay. And so at this time, may I approach, Judge?
Yes.
I am handing you what's been marked State's Exhibit 40. Can you tell me what that is?
That was the fingerprint card I administered for the defendant earlier.
Okay. And how do you know it's the same inking that you took earlier?
Can you rephrase the question, please?
Sure. Did you write anything on that State's Exhibit 40?
I wrote the defendant's name, SID number, and date of birth, and also today's date, which I administered the fingerprint on.
And a SID number, is that a unique identifying number?
Correct.
Okay. And did you sign, I'm sorry, I didn't hear you. Did you sign that today?
Did not sign it, the defendant did.
Okay. And so has it been changed or altered in any way since you last saw it?
No, ma'am.
Okay. Your Honor, at this time, State would offer to admit, State's Exhibit 39, pursuant to 902, 10 self-authenticating, I'm sorry, business records affidavit. Pending any objection from defense counsel.
Your Honor, at this time, I would like to urge an objection with regard to the admission of this judgment in support of one of the accounts in the indictment of felon in possession of the firearm, because I believe that statute is constitutionally impermissible, and that a person's Second Amendment right to bear arms is violated by that statute. And I specifically object to this information being admitted in this case, and urge that the court find the felon in possession statute unconstitutional and strike that count from this indictment.
All right, that will be overruled. State's Exhibit number 39 will be admitted.
And may I approach?
Yes.
Approach the witness. Okay, so State's Exhibit 39 has been admitted into evidence. Can you take a moment to look through it and then let me know what it is?
Okay.
And what is State's Exhibit 39?
It is a Texas Department of Criminal Justice Correctional Institutions Division for a declaration of Sarah H. Wright, which consists of what looks like an ID card on the second page, a judgment of conviction by court waiver of jury trial, which shows the case number, the incident number / TRN number, the defendant's name, and the district court which took place at the time. And the last page consists of these fingerprints that you guys have on file.
Okay, and on State's Exhibit, let me approach it. How many pages is State's Exhibit 39?
5 pages.
Okay, and the certification that is on page 1, how many pages does that say it includes?
5 pages.
Okay, and as previously stated, is this from the Texas Department of Criminal Justice?
Correct.
So this all came over as one packet belonging to them.
Correct.
Okay. can you please let us know, were the prints legible on the drop card that you took from the defendant?
Correct.
And I guess I'm using that terminology. Can you tell us, briefly tell us what a drop card is?
Drop card is what we bring to court to administer the fingerprints for the defendant
Okay,
that we need to compare.
all right. And are the prints on State's Exhibit 40, are those legible prints?
Correct. These are legible.
And were you able to make a comparison, or are you able to make a comparison between State's Exhibit 40 and State's Exhibit 39?
It was.
Okay, and after making that comparison, did you find that those fingerprints matched?
Correct.
And so then those fingerprints came from the same individual?
Yes, ma'am.
Can you please look to page 2, I believe, of State's Exhibit 40? I'm sorry, page 3 of State's Exhibit 40. And is that the start of where the judgment begins?
Correct.
Can you please read out the case number at the top of that page?
Case number D-1-DC-12-904040.
And what court is that out of?
427th District,
And what county?
Travis County.
And can you look a little bit before the middle of the page and tell me what the offense was that he was convicted for?
Assault, family violence, enhanced.
Okay. And can you tell me at the top of where the judgment begins, can you tell me what date that is there?
January the 30th of 2013.
Your Honor, may I approach?
Yes.
And can you tell us what date the judgment was entered?
January 29th, 2013.
Your Honor, the state at this time would offer State's Exhibit 39 into evidence, which is the drop card from earlier.
Yeah, no objection, Judge.
All right, State's Exhibit 39 is admitted.
We'll pass the witness, Your Honor.
Defense? All right, is this witness excused or subject to recall?
Subject to recall, subject to recall.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone except for the attorneys for the state or the defense, and you're not allowed to view anything concerning this trial. Do you understand?
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
State, call your next witness.
The state calls Sylvia Castillo.
Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record, please.
Sylvia Castillo.
State.
Good afternoon, Ms. Castillo. How are you doing?
I'm good, thank you.
Good. Can you tell me what is the name of the company that you work for?
IC Solutions.
Okay, and part of IC Solutions, is that a company that keeps recorded phone calls?
Yes, ma'am.
And how are those records kept?
On our software enforcer.
Okay, and that software enforcer, is it competent of making an accurate recording?
Yes, ma'am.
And does it record the call at or near the time of the event that it's made?
Yes, ma'am.
Okay, and Are those records kept in the normal course of your business?
Yes, ma'am.
And are you the custodian of records for
I am.
those records? Thank you. I would like to approach, Your Honor.
Yes. And both parties, feel free to move about the courtroom.
Thank you, Judge.
Yeah.
I'm showing you what's been marked as State's Exhibit 38. Do you recognize this document?
Yes,
What is it?
it's a CD with a call recording.
Okay, and how do you know that it is a CD of a call recording?
I initialed and dated it. I
Okay.
listened to that.
So you've listened to it?
I have, yes, ma'am.
Okay. Can you, are you able to tell us who made that call?
I can't, I just have it on my record in my bag. I'm sorry.
Okay, would that help refresh your memory
Yes.
as?
Yes, I apologize. I've been sitting outside for a little while.
Your Honor, may we have permission to have the witness grab her, her bag?
Yes,
I just need them.
sure.
Thank you.
No.
I'll mark it.
You-
We're gonna do it tonight.
Ms. Castillo, I'm showing you what's been marked as State's Exhibit 41. Do you recognize this document?
Yes, I do.
Okay, please refresh your memory, just don't read to that.
Yeah, absolutely.
Are you able to tell us who made the call in State's Exhibit 38?
Yes, Dominic Nicholson.
Okay. And are there any unique identifying numbers associated when a person makes a call that your company records?
Yes, we have a call sequence number. It's a unique identifier of every phone call.
So every phone call gets its own unique identifying number?
Yes, ma'am.
Okay. And what about the people who are actually making the call? Do they also have a unique identifying number?
Yes, they have the ID number with a passcode.
Okay. And so does this defendant have his own ID number with the passcode for this call?
Yes, ma'am.
And was that ID number and passcode used to make this the call on State's Exhibit 38?
Yes, ma'am, it was.
And are you able to tell me what phone number was associated with the call?
Yes,
And what was that?
it's 210-758-6027.
And can you tell me when this call was made?
10/12/2022.
And can you tell me what time the phone call was made?
At 1922.
And is that military time?
Yes, ma'am.
So would that be 7:22?
7/22.
All right. And State's Exhibit 38, is that a true and accurate recording of the call that was made?
It is.
Okay, has it been altered in any way?
No, ma'am.
At this time, Your Honor, the state would offer to enter State's Exhibit 38. Well, state would offer to enter in State's Exhibit 38A pursuant to the court orders.
May I speak to witness on board hour?
Yes,
You do not know Dominic Nicholson, do you?
No, ma'am, I don't.
You've never spoken to him, have you?
No, ma'am.
You wouldn't be able to identify his voice, would you?
No, ma'am.
And the company that you work for, is it possible that someone else could make a call under someone else's ID?
We have a voice verification associated with the 6-digit ID number plus the passcode. So if everything matches it, then it goes through.
Okay. But it does happen that people use each other's IDs, correct?
That can happen, yes, ma'am.
Nothing further, Your Honor. I just would object that she has lack of personal knowledge to link the voice on the call to my client and lack of foundation and hearsay, relevance, and balancing.
all right, with regards to hearsay, that objection will be overruled. Do you have a response to defense counsel's objection to foundation?
I do, Your Honor, if I could just ask the question, ask a couple more questions.
Yes.
Sure. Ms. Castillo, you said earlier that if everything matches, then you're able to tell that it's from this defendant.
Yes,
Did everything match in this case?
yes, it did.
Okay. So was this phone call made by the defendant?
Yes.
All right, then with regards to foundation, the objection will be overruled. The court is performing a balancing test. The court will find that it's more probative than prejudicial. All right, State's Exhibit 38A is admitted.
And Your Honor, may we publish?
Yes.
Amber, what are you- The public safety message. You're the debate.
Worried about this, huh?
I've been worried about you. I've been worried about you. I've been having bad dreams. Work, shit making me out. It's tripping me out. But I'm bad. I've been having bad dreams that she's been leaving me. That we both think.
I'm not leaving you, baby. I'm right. You hear me?
Yeah. Hey. I think take what's on the phone. You know what I'm saying? Talk to you every little thing. I've always done him.
And the state will pass the witness, Your Honor.
No further questions, Your Honor.
All right, is this witness excused?
From the state, yes.
Excused?
Yes.
Oh, yeah.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense. Thank you. State, call your next witness.
State calls Investigator Fermin Guzman.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, have a seat, and state your name for the record, please.
Name is Fermin Guzman.
State.
Thank you, Your Honor. Investigator Guzman, how are you employed?
I'm an investigator with the Bexar County Sheriff's Office.
And how long have you been with Bexar County Sheriff's Office?
I've been 19 years with the Bexar County Sheriff's Office.
And what assignments have you had with Bexar County Sheriff's Office?
So throughout my career with the Sheriff's Office, I've been assigned to the jail. I've been a patrolman for a few years. I've been a narcotics deputy for a few years as well. I've been a mental health deputy also for a few years, and promoted to an investigator, and I've been an investigator for about 3 years now.
So as an investigator, what are your duties?
As an investigator is reviewing cases, responding to certain cases, felony cases, and also filing cases when need be.
So as an investigator, how are you assigned cases?
So there's a couple of ways. One way is you get assigned through an RMS system, it's a report management system where you get assigned cases that were filed at large. That's usually assigned by a supervisor. Another way is by responding to a case, mostly felonies, and that's basically both ways how we get assigned cases.
Okay. And if there are multiple investigators on duty, how does that assigning of the cases work?
As far as responding to the cases, it's pretty much a rotation. There's really no set who takes the first one. It's just whoever's available takes the first one. The next case comes up, the next investigator takes the next one, and so on.
So you stated that you go out to felonies, is that correct?
Yes.
Do you go out to every single felony call?
I wouldn't say all of them, but most of them, yes.
Okay. How do you determine what felony calls you go out to the scene for?
Based on what the deputy, what details the deputy provides, evidence, suspects, complainants, and then just, I guess, the nature of the call.
After you go out to the scene, excuse me, and once you finish your investigation, what are your options from there?
So after responding, do the investigation at the scene, do some research, and if there's an arrest to be made and the suspect's available, we'll arrest them on site. Or there's also another option, if the suspect's not there, we'll do an arrest warrant for them, or simply just file that large. And if there's no offense committed, then really do nothing after that. Just document the incident.
Okay. So I'm gonna take you back to October 10th of 2022. Were you on duty on that date?
Yes.
And do you remember what shift you were working?
It's first shift.
And what hours is that first shift?
Our first shift is from 8 a.m. to 6 p.m.
And were you assigned a case that day?
Yes.
And when you are assigned a case, does it have any unique identifiers that you use in order to identify a particular case?
The case number, address, people involved.
Okay. And do you know the case number in this case?
Not by memory, no.
Okay. If I handed you your report, would that help refresh your memory?
Yes.
Handing you what's been marked as State's Exhibit 42. Can you tell me what this is?
This is going to be the Spears incident report. The incident that happened October 10th.
And is your report part of that?
Yes, it is.
So what was the case number in this case?
So the case number assigned to this case is going to be 2022-BCSO-021094.
And what type of case was it?
The problem nature is a shooting, which turned out to be an aggravated assault with deadly weapon.
Did you go out to this scene?
Yes.
And why did you decide to go out to this scene?
The details provided to me by responding deputy and patrol supervisor. That's pretty much, yeah, they decided for me to go.
Okay. And were you the lead investigator on this case?
Yes.
What address did you go to in order to start your investigation?
So the first address I went to was the 12,900 block of East Loop 4, 1604 North.
And is that location in Bear County?
Yes.
And when you arrived, who was at that location?
I met with two complainants, Jayla Seti White and Conrad Dorn, and his vehicle.
Okay. And did you talk to them?
So yeah, so the location where I met them was on the side of the highway. Conrad's vehicle was disabled due to a flat tire, so we relocated off the highway onto a parking lot in a nearby shopping center. And spoke to both Jayla and Conrad there.
And why did you decide to relocate?
It's safer there, off the highway.
Okay. Was the car relocated as well?
Correct.
What kind of car was the vehicle?
It was a maroon SUV.
And you said there were two people there.
Right.
Is that correct?
Yes.
Okay. And did you take their statements?
Yes.
When you took their statements, where were you?
So I interviewed both of them, got their statements from both. The interview was done inside my vehicle, both separate, right? One after the other.
So there was no one in your vehicle besides you and whoever you were speaking to, is that correct?
Correct.
Were any interviews conducted that were in the presence of others?
Yes, later on in the investigation, yes.
Okay, but at this point, you did not speak to them around other people.
Correct.
Did you look at the vehicle at all?
Yes.
Were there any defects on the vehicle that you noticed?
So when the tow truck had arrived, they changed the tire that was flat, which was, I believe, the passenger side rear tire. And it did have a defect. We moved it around. You could hear something inside that tire. I also did notice a defect on the tailgate back of the vehicle, right above the license plate. There was a small bullet defect.
Okay, and so that defect, what kind of defect did you notice it as?
As a bullet hole.
Okay, and is that something that you would recognize through your training and experience?
Yes.
So the towing truck changed the tire at the scene? Is that
Yes.
correct?
Yes.
Okay. And then what was done with the flat tire?
Conrad took it with him, and I did let him know if he changed out the tire and they found something, just let us know.
Okay. So, could you tell what was inside the tire?
No, I couldn't see what was inside. I mean, you could hear something was in there. I couldn't see.
And was that item eventually recovered?
Yes,
And do you know what that was?
it was a projectile from a bullet.
Did any other officers make that particular scene with you?
Our crime scene deputy, Tibbs, responded to photograph
Okay. And what did he photograph?
the vehicle's tire, both Jayla and Conrad.
Did you do anything else at that scene?
No.
And what did you do after that?
So I responded to the address of where then the alleged shooting had happened,
Okay, and what was that address?
which was 8619 Key North Way.
And is that in Bear County?
Yes.
And what did you do once you arrived?
So I met with the investigator there, got a briefing of what he has done there, and then spoke to other witnesses.
Did you take any statements?
Yes.
From who?
Jairus Sadie White.
And at that point, had a suspect been detained?
Yes.
In order to enter a home, what do you need to have?
Consent from the homeowner. Well, first you need probable cause, right? Or a reason to go in there. then you would need consent from the homeowner.
Object to relevance.
Sustained.
I ask that the jury be instructed to strike that testimony.
All right, ladies and gentlemen, you're to disregard that last answer from the witness.
I ask for a mistrial due to violation of the constitutional rights under the United States and the state of Texas to a fair, impartial trial and to protect the defendant's right to be presumed innocent and to the burden of state burden of proof being on state at all times.
All right, that'll be denied.
In this case, did you have a search warrant?
Yes,
And what location was that search warrant for?
for that 8619 Key Northway.
Okay. And did you search that address?
Yes.
Did you find anything of evidentiary value that pertained to this particular case?
Not really.
Were there any firearms that were recovered?
No.
In your search, did you search the yard as well?
Yes.
Anything that's been marked as State's Exhibit 43, do you recognize this?
Yes.
Okay, and what is this?
Looks like the backyard of the address we were searching.
And where is this photo from?
What do you mean? From the body cam footage of my body cam footage.
Your body cam, okay. So when you were searching the yard, was there anything that stood out to you in the backyard?
So the fence, there was a, I guess, opening defect. I don't know if it was broken off or what, but there was an opening onto the neighbor's yard.
Okay. And does State's Exhibit 43 fairly and accurately depict that defect in the fence?
Yes.
And has that been altered or changed in any way?
No.
And state offers State's Exhibit 43, I'm showing to the fence.
Object to relevance, Your Honor.
All right, can I see the exhibit, please? All right, the objection to relevance will be overruled. State's Exhibit 43 is admitted.
Was that defect concerning to you?
Yes.
And why was that defect concerning?
So we were searching, part of the items that we were searching was a firearm, and that defect, I mean, was large enough to fit a firearm through.
And were any firearms recovered?
No.
What else did you do for your investigation?
So for that day, talked to other witnesses, and then the following day did a canvas of the area, meaning we walked the area, we see cameras that would point toward directions where the incident would have happened, and find other potential witnesses as well.
So you mentioned cameras.
Yes.
Were there any cameras that you had seen that were pointed toward the area that the incident allegedly occurred?
No.
Did you do any further investigating regarding the cameras?
Yes, so we at the time of this incident, we had a program that's called a ring geofence. This is pretty much a website where you put out
Your Honor, I would
incident.
object to this completely.
What is your objection?
I have no notice or information whatsoever about any kind of geofence search, electronic search, whatever they're.
May we approach?
Yes. All right, State, you can ask your next question.
Thank you, Your Honor. Did you do any further investigating regarding the ring cameras? Did you find any video of the incident?
No, I did not.
Were you able to complete a thorough investigation regarding the cameras?
Yes.
Okay. Um, did you do anything else that day, that particular day?
When I did the canvassing the days after the incident or day after the incident.
Yes, after you did all of
Yes, I spoke to other witnesses or another witness.
it. And were you able to get more information about what had happened?
Yes.
Did that information lead you to looking at or to look for anyone else besides the person who had been taken or who had been detained?
Yes.
Okay. What description of him were you given?
A male wearing white shirt.
Okay. Were you able to identify that male?
So I did identify a male that matched the description. But positively identifying with the lineup, I couldn't. Being that the person that gave me this information was, I couldn't reach him, couldn't find him, locate him.
Okay. And at that time, did you have a last name of that person?
Yes.
Did you have a last name of the person who had given you the ID?
Oh, no.
Um, was there any evidence linking him to the shooting, this person in the white shirt?
No, not to the shooting itself. There was information that he was involved in the actions after the shooting.
And what happened after the shooting?
So the scene, there was no shell casings where the shooting was reported to have occurred, and this male was identified to have been.
Check to hearsay. I think. there being a-
Sustained.
Okay. Ask the jury, court to instruct the jury to disregard any testimony with regard to what somebody might have said to him or led him to believe or.
All right, ladies and gentlemen, you're instructed to disregard the last statement.
So was there any evidence that you found that pointed to this person in the white shirt being the shooter?
No.
Okay. So I'm gonna take you to October 13th now. What happened on October 13th?
So Mr. Conrad contacted me and informed me that he had found
Yeah, hearsay.
Sustained.
Without saying what anybody told you, what happened on that day?
I recovered a projectile from Mr. Conrad's vehicle.
Okay. And where was it found? Where was this projectile found?
Your Honor, hearsay, object.
Your Honor, he has personal knowledge.
He does not have personal knowledge.
He,
All right, so everyone, just give your objections to me. Ask the question to lay the foundation, and then I will hear objections.
Investigator Guzman, did you meet with Conrad on that day?
Yes.
Okay, where did you meet with him?
It was at my office, 207 North Comal, outside.
And did you go outside?
Yes.
And did you see the projectile?
Yes.
Where was the projectile?
He handed it to me.
Okay. What do you do with evidence that is handed to you?
It's in place in our property room. And then if need be, it would be sent off to our Berkana lab.
And is it packaged?
Yes.
Okay. What was the weapon identified as in this case?
Wait, Your Honor. I object to that. There hasn't been a weapon identified in this case at all. So she's asking for speculation and,
All right, lay the foundation.
Did witnesses identify what type of weapon was used?
A handgun.
And is that a firearm?
Yes.
And are firearms capable of causing death?
Yes.
Are they capable of causing serious bodily injury?
Yes.
Are they capable of causing regular bodily injury?
Yes.
We pass the witness, Your Honor.
Defense?
Yes, Your Honor, thank you. Mayor Perch?
Yes.
This document that you used to refresh your memory.
Okay.
Search the house,
Yes,
you search the yard
yes,
of the particular house, and you search the backyard,
yes,
and you search surrounding areas.
yes.
And it was, how many people joined you in that search?
Um, can't give you an exact number, but there were several investigators that assisted me.
You did not recover any casings,
Correct,
you did not recover any firearms,
correct.
you did not recover any evidence with regard to the shooting.
Projectiles, yes.
Okay. And you listed in the reports that you make, you list, witnesses, correct?
Yes,
And, the purpose of your investigation is to be thorough,
yes,
correct? Because you know that it's gonna be possibly used in a criminal prosecution, right?
yes,
And so collecting all information is important, correct?
correct.
Because you want this jury to have as much information as possible to make the right decision, correct?
Yes,
And so, you arrived at the scene, after you went out to the vehicle scene, right? And then you went to the home,
yes,
and there were several people outside, correct?
correct,
Including neighbors and others, correct?
correct.
Okay. And so where is it that you noted the name and contact information of those people?
Some of them are on the report, on the RMS report itself.
That you'd agree with me, not all,
Right.
not all. And, did it strike you odd that you didn't find the casings there?
Yes,
And that would be a concern because someone who's picking up casings maybe tampering with evidence, right?
correct.
And so, you became aware that there was an individual, another possible suspect, correct?
Suspect to,
Or that you had mentioned that there was another person that you had been identified connected to the event, correct? Or shortly after the event, as far as,
suspect to, I guess, collecting evidence.
okay, well, you never spoke to that person, correct?
Right.
And you never, and so we don't know who that person is, right?
I mean, I identified someone, but you know, like I said, I didn't get a positive ID through a photo lineup.
Okay. And that person may have been actively engaged in committing a crime, correct?
Correct.
But we don't have any information as to that person's contact information, correct?
Other than just his identifiers.
Okay. And those identifiers include that this person lives in the exact vicinity of this house, correct? Maybe not in this house, but next door.
Right, nearby.
Nearby. And how many officers were at the scene that day, do you think?
I couldn't tell you, maybe about 10 or 5.
And did any of those officers bother to get the names and contact information of the young men next door?
If it's not a report, then probably not.
I'll pass the witness at this time.
State?
Investigator Guzman, are there other investigators helping you out on scenes?
Yes,
So while you were doing one thing, are they doing something else?
correct.
And all of that information that they are presumably collecting or talking to people is shared with you.
Yes,
That information, would that information make it onto your report?
and to the RMS report itself, sometimes the investigator that assisted me would have it on his report.
Okay, but it would be on his report,
Should be,
presumably
yes.
not yours,
Right.
always. Okay. So the other person that you were looking at, what were they said to have done?
You're on our object to hearsay.
Your Honor, she opened the door with her line of questioning.
All right. It's hearsay. That'll be sustained.
So you stated a moment ago that you didn't find any
Your Honor,
casings.
object to leading.
All right, let me hear the question and then I'll answer your objection.
So you didn't find any casings because a concern of yours would be that someone is picking them up.
Your Honor, I object.
All right,
She's
and your
leading-
objection
Leading the witness.
sustained, and you all can remain seated for your objections. It makes it easier for the court reporter to hear. The objection is sustained to leading.
You stated you had another suspect. What
Your Honor,
crime,
objecting. I'm sorry, to leading again, I'm sorry.
All right, that'll be overruled.
what crime was he a suspect for?
Tampering with evidence.
And what evidence did he tamper with allegedly?
Collecting shell casings from the street. I'm sorry, would be the evidence of the aggravated assault that had committed.
Okay, but
We're talking.
okay, so specifically the guy, this other suspect, right, in the white shirt. What evidence would he have tampered with?
The evidence that would be involved in the aggravated assault,
And what was that evidence?
shell casings.
That's speculative, Your Honor, I object and ask the court instructor to review.
All right, that'll be overruled.
Peter Guzman, I'm showing you what has already been admitted as State's Exhibit 5. Do you recognize this area?
Yes.
And what area is that?
This be the street where the shooting occurred. Where we're dispatched to.
And is that the neighbor of 8619?
It appears to be yes.
Is there someone in all white in that picture?
Yes.
Pass the witness, Your Honor.
Defense,
Investigator, the time that you went out to the vehicle in 604 and Pat Booker. Neither individual that you, were both individuals still there?
Yes.
Jay White and Conrad Dorn were both still there?
Yes.
And neither one of them were injured, correct?
Correct.
And so at no time has any allegation been made that any actual injury occurred, correct?
Correct.
Physical injury, correct? That you noted, I guess, defects in the vehicle with regard to bullets or in the tire.
Correct.
And you were out there because it was reports of a shooting and an alleged aggravated assault, correct?
Yes.
And this vehicle had been shot at and hit, correct?
Right.
And you have the ability to tow and impound a vehicle, don't you?
Yes.
And you have actually a place to take vehicles to inspect and investigate, correct? And search.
Yes.
I mean, to collect and process evidence.
Yes.
And you take vehicles all the time to go process for evidence, correct?
Yes.
And in this situation, you release the vehicle back to Mr. Dorn, correct?
Correct.
And he had removed the tire from the vehicle. And I guess the spare tire was placed on or something like that, correct?
Right.
I mean, he drove the vehicle off.
Correct.
And he drove off with the tire.
Right.
That was removed, correct?
Yes.
And it was days later before you met up with him again, correct?
Correct.
And at no time were you involved in extracting any bullets from any tires or from that vehicle, correct? Or
Correct.
cases?
Correct.
In fact, you have no casings in this case, correct?
No, I'm sorry.
No bullet casings in this case other than what Mr. Dorn handed to you, correct?
Correct.
And no weapon.
Correct.
Correct. And we have no information with regard to the other suspect, correct? No contact information with regard to the other suspect, correct?
Correct.
I pass the witnesses.
any further questions?
Just briefly, Your Honor. Just to clarify. What crime was that other suspect alleged to have committed?
Be tampering with evidence.
So not this charge, aggravated assault with a deadly weapon, correct?
Correct.
We pass the witness, Your Honor.
Defense,
Yes, investigator, we have lost the opportunity to conduct the GSR kit on this other suspect, correct?
Correct.
And in fact, you do GSR kits because of the potential evidentiary value that they have, correct?
Correct.
And, we. Your investigation led you to, target Mr. Nicholson as the only suspect, correct?
For the aggravated assault, yes.
For the aggravated assault. And, you would agree that there were other men at the scene matching his description, correct?
No,
Did you see some, African men next door on the driveway?
yes,
And would you agree that they were similar in build?
similar, yeah.
And, where are their names and contact information noted?
No,
I pass witness at this time, Your Honor.
Investigator, why didn't these other men match the description?
oh, the name and, I guess how this person was identified. The shooter was identified, how Dominic was identified.
How was he identified?
As a stepfather of Jayla and the male that lives at that address and by name.
Pass the witness, Your Honor.
We never have any interviews with any of these other gentlemen at the scene, do we?
Right.
In fact, we don't even know if Jayla was involved with them or not, do we?
No.
You know, if Jayla was dating any of them?
Objection, relevance, and speculation.
All right, with regards to speculation, that'll be overruled. With regards to relevance, that'll be overruled.
There was no investigation conducted concerning potential other relationships out there, correct?
Correct.
I pass the witness at this time, Your Honor.
We have no further questions, Your
All
Honor.
right, is this witness excused or subject for a recall?
Subject to recall.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone except for attorneys for the state or the defense. Make sure you're available if you recall. Thank you.
Thank
State, call your next witness.
The state would recall Jayla Sadie White.
Okay. You're still under oath. State.
Hi, Jayla. Thank you for coming in today. Did you have any relationships with anybody at 8623 Key Northway?
What kind of relationships? Just like familial?
Dating relationships. I'm
Oh,
sorry.
no.
Okay. Were you friends with anybody at 8623 Key Northway?
Oh, no.
When the Uber, were you outside when the Uber pulled up?
Yes, ma'am.
So you were, let me back up. After you got in the car and after you were fired at or before, did you see Conrad, the driver, with any weapon?
No, ma'am.
Did you yourself have any weapon?
No, ma'am.
Did anybody inside that car shoot any weapon?
No, ma'am.
Did anyone inside that car have any interaction with the defendant at all?
No, ma'am.
After the shots were fired and you ducked down, why did you duck down?
I was afraid it'd hit me, could kill me or injure me severely, so just for safety.
And I'll pass the witness, Your Honor.
Defense.
And you weren't actually like physically injured that day, correct?
No, ma'am.
And Mr. Dorn was not physically injured that day either.
No, ma'am.
And you never saw, when you returned back to the house, you didn't see a gun anywhere. did you?
No, ma'am.
And you've been in that house since 2015. Do you know how long the neighbors have been there?
No, ma'am.
Do you know generally their ages?
No, ma'am.
Teenagers, 20s, 30s?
There's a mix of people, so I'm not sure. There's some teenagers, some older people.
And some young adults, adult males, correct?
Yes, ma'am.
I pass the witness at this time, Your Honor.
No further questions, Your Honor.
All right, is this witness excused?
Subject to recall.
All right, the rule has been invoked. Please remember my previous instructions. Thank you. State, call your next witness.
State calls Juan Antonio Melendez. And Your Honor, we would need an interpreter. She is on the way.
Okay. Jurors, do you need a short break? All right. So remember my previous instructions and I'll have us come back at 3:25. All right, everyone, please rise for the jurors.
It, I don't think I'm gonna have any witnesses, so in the state rests. In close, I would, or rest, I would like to approach to request this, direct verdict.
Okay, all right, we'll do that outside the presence of the
Okay.
jury. And then after I make my ruling, if I rule in your favor, of course, we're done. But if I do not, we're gonna end up going into closing arguments today.
Okay, will you give us a few minutes to sort of collect our thoughts?
Yes.
Okay.
Maybe see that.
Deputy, yes. Investigator who's law enforcement firearm. And then also that a firearm is a type of weapon because it could cause what you said took is one, it could cause death, serious bodily injury, and it's a weapon is anything. Yes, and we have shooting.
All right, we're ready.
Ready, Judge?
Yes.
All right, for the jury.
Everyone please be seated. State, call your next witness.
State calls Juan Melendez.
All right, we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, if you'll state your name for the record, please.
Your Honor, the interpreter's name is Jorge Valle.
All right, and sir, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sí. Yes.
All right, you can lower your hand, state your name for the record.
Mi nombre es Juan Meléndez.
My name is Juan Melendez.
State.
Good afternoon, Mr. Melendez. I want to direct your attention to October 10th of 2022. On that day, where were you at? Where were you at?
Yo estaba en el supermercado.
I was at the supermarket.
Okay. After you finished with the supermarket, where did you go?
A mi casa.
To my house.
Iba para mi casa.
I was going to my house.
And what is the street that is on?
Que está mi casa.
My house?
Yes.
En Kino Web. Convertese. Kino Way. Key Lago.
Key Largo?
Yeah.
Okay. And would would the street name Key North Way be familiar to you?
Yeah.
Key Northwest?
Yeah.
Yes.
Esa es mi casa.
That's my house.
Okay. I want to talk to you about when you come from the store. Are you able to pull directly into your home, or are you stopped by any road signs?
No, tengo que entrar por una calle.
No, I have to go in through a street.
Okay. And on that street, do you recall that street name?
Bucky Way.
Milky Way?
Bucky Way.
Bucky Way.
Okay.
And excuse me, just one moment. Everyone, just give me 2 minutes, please.
Oh, yes, Judge.
It's literally just the street and then the stop sign that he was at. Just a minute.
All right.
All right, everyone, please be seated. All right, State, you may continue.
Yes. Showing you what's been marked as State's Exhibit 1A. Do you recognize this?
Yes,
What is it?
this is a map of my neighborhood.
And if it's facing like this, is this the top of your neighborhood?
Yes, that is the street.
And what street is this right here?
That is Key Norway.
And what street is this?
Marco Way.
Excuse me, what exhibit number is that?
1A.
Has that been admitted into evidence?
It is not, this is just for demonstrative purposes.
All right. In defense, you can move around. All right, you may continue.
Juan, can you please point out your house on this exhibit? And it was, does he have permission to come and do that?
Yes. You may step down. Watch your step, though.
This is my house.
And if you would like, I'm gonna have you, you said this is your house?
Yes.
Can you please write your house there? And when you were coming home from HEB, which route did you take?
This one.
Okay, and at the corner of this street, what is there?
There was a house here. A stop sign.
Okay, and I'll go. So I'm just gonna write stop sign. All right. Were you stopped at the stop sign?
Yes, right here. This is right to the front.
And on October 10th of 2022, was there anything obstructing your view to your house?
This truck was here.
Okay, could you still see this side of your street?
Yes, I could see this way.
Okay. All right. And you said you were stopped about right here? Please move it to.
I was coming this way. Then I stopped around here.
When you stopped there, could you see or hear anything that alarmed you?
When I was coming, I heard the shots.
Okay, you said when you were coming, where were you on this, on these streets when you heard the shots?
I was coming this way.
Okay. When you pulled up to the stop sign, what did you see?
I saw the man with the weapon.
What man did you see?
Can I look at him?
Yes,
The neighbor.
okay. The neighbor, and who do you know him as?
¿Cuál es el nombre?
Okay,
The name, no.
the name, no, okay. When you were coming down, or I'm sorry, when you stopped,
Yes.
where were you when you first saw your neighbor?
I was in my car.
Okay, and where on the street were you when you first saw your neighbor?
When I saw the neighbor,
Yes.
right here.
And what, were you in a vehicle or were you outside of your vehicle?
What is? Outside his vehicle.
And I'm just gonna ask that question one more time. Were you in your
¿Estaba
vehicle
usted en su vehículo?
or were you outside your vehicle?
Estaba afuera de su vehículo. Estaba adentro. No, I was inside my vehicle.
Okay, and where was your vehicle parked? Is this,
¿Dónde está su vehículo? No, aquí estaba. I was here. No, I was here in my vehicle. And his vehicle was here.
okay, let me mark that. What color is his vehicle?
Ray,
Okay. And you said you saw this man, your neighbor. What was he wearing?
he had a black shirt.
And did he have any headwear on that you remember?
No,
All right. So he was in a black shirt. How were his arms positioned?
He had the gun here.
And how did he have the gun?
¿Cómo tenía la pistola? This is the street,
Okay,
like this.
so his car, what direction was his car facing?
This way.
So the front of his car was like that,
Yes,
but up here.
right here. This is the sidewalk.
Okay. So if his car was facing that way,
Yes.
how were his arms positioned when you saw him?
Well, like this.
And just for the court record, the witness is demonstrating his arm up. And from where you were at, did you tell which arm he was using?
The right, the left, I'm sorry, the left.
Okay. And could you tell if he had anything in his hand?
A gun.
Okay. All right. And then, what is the address of the neighbor that you saw? That's all I'm gonna use this for right now, if you wanna have a seat. When you pulled up to the stop sign, how many gunshots did you hear?
Había, porque venía del nuevo, pero ya había escuchado los disparos.
I was coming to the neighborhood, but I have heard the shots before. 3.
Okay. After, I'm sorry, did you see the defendant with the gun in his hand?
Yes,
Okay. Did you see what he did with the gun after you After he had it out with his hand.
Se la guardó.
He put it away
Where did he put it away?
right here.
And could you stand up and gesture for us where he put it away?
Right here.
So is that in the front of his waistband?
Yeah.
Yes,
Okay. What did you do after you heard the shots and saw the defendant?
Pues, seguí con mi carro para mi casa.
I kept on going in my car to my house.
Okay. And why did you drive in the direction of your neighbor after you heard the gunshots?
Porque esa es mi casa.
Because that's my house.
Hay que tener. Esa es mi casa. Esa es mi casa.
That's my house.
Okay. When you got to your house, where did you park your car?
En mi parking.
In my parking
In your driveway?
Driveway.
driveway, yes.
When you parked in your driveway, where was your neighbor?
Vecino mío estaba.
My neighbor was,
Iba a entrar para la casa,
he was going inside the house,
pero me dijo, I'm sorry.
but he told me, I'm sorry.
Where did he talk to you?
Iba a entrar a su casa.
He was going inside his house,
Yo estaba acá en el carro,
And I was-
buscando las bolsas.
over here in my car, looking for my bags.
Okay. Did he say anything else besides I'm sorry?
No, eso es todo.
No, that was it.
After he said I'm sorry, where did he go?
A su casa adentro. Y yo me
To
fui a
his
mi casa.
house inside, and I went into mine.
Okay. And did you see him after that?
No,
No,
And at this time, was he still wearing a black shirt?
cuando lo vi, ¿dónde?
when I saw him where?
When you talked to him outside of your house?
Fuera su casa.
Sí, porque él iba entrando para su casa.
Yes, because he was going inside his house.
At some point that day, were you approached by anybody at your house?
¿Alguien en su casa?
En ese día sí,
At that day, yes.
los policías,
The policeman afterwards.
And did you have an opportunity to talk to the police?
Tuvo una oportunidad de hablar con la policía.
sí,
Yes.
When you were stopped at the stop sign,
Tenido en alto stop sign.
did you see anyone else outside
Alguien más afuera,
besides your neighbor with the gun?
aparte de su vecino con la pistola.
no,
No.
Did you see anyone else with the gun?
¿Te vio alguien más con pistola?
no.
No.
At the time that you heard the shots, was there anybody
Había alguien
outside of this house right here?
aquí.
And for the record, I'll be the best house.
No veo que tú puedes sacarse de la casa.
No me acuerdo.
I don't recall.
But you don't,
Pero usted-
but you didn't see anyone else outside.
¿Alguien más afuera?
That's the answer, Your Honor.
No.
Overruled.
How well did you know your neighbor?
¿Qué tan bien conoció usted a su vecino?
No mucho.
No, not very much.
Had you seen him around?
Pero he visto.
Bueno, yo siempre estoy afuera, a veces lo veía yo.
Well, I'm always outside. Sometimes I did see him there.
And would you, Mr. Melendez, were you subpoenaed to be here today?
¿Usted fue citado para estar aquí el día de hoy?
Sí.
Yes.
So it's by court order
Por la orden del juez.
that you are testifying. Is that,
Your Honor, I object to relevance.
Sustain.
I'll pass the witness, Your Honor.
Defense.
Thank you, Your Honor. Good afternoon, Mr. Melendez. I have a couple of questions here. So, how long have you lived in your neighborhood?
¿Ha vivido usted en este vecindario?
¿Ah?
How long have
¿Cuánto
you lived?
tiempo ha vivido usted en este vecindario?
15 años.
15 years.
Is it lovely neighborhood,
¿Es un
correct?
vecindario encantador?
Yeah.
Yes.
And these houses, they're pretty close together, would you agree?
La nota, correcto.
Sí.
Yes.
Like you can probably see from one window into another
La otra ventana.
if the curtains were open.
Porque no están abiertas.
No,
No.
No, okay.
hay una verja.
There's a fence.
There's a fence, okay. But you're in a two-story home?
¿Está en una casa de 2 pisos?
Sí.
Yes.
Okay. Or some two-story and some one-story?
Uno de 2 pisos, uno de 1 piso.
De un piso.
1 floor.
Porque esas que están acá
Because this one's on this side
son las más viejas
are the oldest ones.
y las otras de ellas son las más nuevas.
And the other ones on that side are the newer ones.
These here,
¿Están acá?
Nuevas.
No.
newer ones. And they're large, they're
Son
pretty
grandes,
large
son
house,
grandes.
correct?
Yeah.
Yes.
And so this home on this corner, that's a pretty large one, correct?
Bastante grande, correcto.
This one right here.
Sí.
Yes.
And that's also a
Y también
two-story
de 2
house,
pisos,
correct?
correcto.
No, esa
No.
es de una.
1 story.
One story, okay. And there's some trees or brush right here at the corner, correct?
Esquina, correcto.
No,
No.
Okay. What's there at that corner then?
¿Qué es lo que hay en la esquina?
la esquina lo que hay es un terraplén y,
At that corner, there's sort of like a ramp
y está la acera.
and the sidewalk.
Okay. And you're outside a lot, correct?
Yo, sí.
Me, yes.
And so you have seen other young American males in the neighborhood, correct?
Yes.
Have you seen the play basketball here
Yes.
and have parties here in the garage? This is two houses down.
A veces.
Yes, sometimes.
After, you didn't call 911, correct?
No, ya no.
No, I did not.
And once you got home, did you get home pretty quickly after you saw this?
Sí, me parqué. Llegué en mi carro y me parqué. En
Yes,
mi carro.
I parked. I arrived in my car and I parked.
In your driveway?
Driveway.
En mi parking.
At my parking.
And did you go inside your home?
Entró dentro de su casa.
Cogí mis paquetes.
I
Yo
picked up,
llegué con compra del supermercado.
I picked up my bags. I had purchased things at the supermarket.
Okay. And then you took them inside the house?
Se lo llevó dentro de la casa.
Sí.
Yes.
Okay. And how many bags of, how many trips did it take you to get your groceries in?
No, hice un viaje de como de 4 bolsas.
One trip with 4 bags.
Okay. And once you were inside your house, did you stay in there for quite a while?
Sí.
Yes.
I have no further questions at this time.
Mr. Melendez, why didn't you call 911 when you heard the shots?
I'm sorry, will you please repeat the question?
Oh, I'm sorry. Why didn't you call 911 when you heard the shots?
No me pasó por la mente.
I didn't think about that.
Did you actually see your neighbor shooting the gun?
¿Ah?
Usted vio a su vecino disparando el arma.
Yo lo vi con el arma, sí.
I saw him with the weapon this way.
And did he fire the weapon in your line of sight?
Y él disparó el arma mientras usted lo estaba viendo.
No, la tenía así
No, he had it this way.
y había el carro que vi era Blinker en un color vino que se fue.
And then I saw a wine colored car that left.
So you saw the
Yo,
gun pointed in the direction of the wine colored car?
en la dirección del carro color vino.
Yeah.
Yes.
Did you see anyone from that wine colored car shooting?
¿Usted vio a alguien que está dentro del carro de color vino que estaba disparando?
No.
No.
No, I'll pass the witness, Your Honor.
You
Usted,
know, you have seen
usted ha visto
Dominic around the neighborhood, correct?
por el vecindario, correcto. Yes.
And would you agree that he's right-handed?
Él usa su mano derecha.
Objection to speculation.
Overrule.
Ahí no me acuerdo.
I don't recall.
I have nothing further at this time.
The neighbor that you saw with the handgun and the black shirt, is he in the courtroom today?
Yes.
Can you point him out by an article of clothing?
Se lo puede señalar y decirle que está vistiendo una prenda de vestir. ¿Qué color?
Tiene la camisa de hoy,
Today,
Yes.
blanca y la corbata.
he has a white shirt and a tie.
And if the record could reflect, the witness has identified the defendant. And the state will pass the witness, Your Honor.
I have nothing further at this time, Judge.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone or view anything regarding this case. Do you understand?
Yes.
All right, thank you. You may step down. State, call your next witness.
Your Honor, may we approach?
Yes. Just announce that you're resting. You either rest now or you call your next witness. Okay, thank you. Sure. No problem. All right, state, call your next
The
witness.
state will rest at this time.
All right, ladies and gentlemen, we're going to take a brief recess and then we will be back. And by brief, I mean I will have you all back by 4:15. Please remember my previous instructions. Everyone, please rise for the jurors. Please be seated. State, when we left, you rested, is that correct?
That is correct, Your Honor.
All right, defense.
Your Honor, at this time, I would like to admit and if it's published to the jury, a brief stipulation that the state and the defense have agreed to.
Yes.
You know, from the-
And what
Or
is
do you want me
exhibit,
to just read it?
what exhibit number is it?
Oh, that's Defense Exhibit 1.
All right.
Do you mind if I-
And
Okay.
there's no objection. My understanding, there was an agreement reached between the state and the defense with regards to defense exhibit number 1. Is that correct?
That's correct, Your Honor.
All right, so defense exhibit number 1 is admitted, and defense, you may read it into the record.
Okay. The parties stipulate that Conrad Dorn was served by the DA investigator Mike Jennings on January 15, 2025, and that the injury and hospitalization of Conrad Dorn referred to in his testimony is unrelated to this matter.
Thank you.
Thank you.
All right, defense, any other witnesses?
No, Your Honor.
And do you rest?
I do. I rest.
And state, do you close?
We do, Your Honor.
And defense, do you close?
Yes, Your Honor.
All right, ladies and gentlemen, I'm going to read to you the jury charge, what is known as the charge of the court. You do not have to memorize it. You will have a copy, not a copy, but the original with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Dominique Nicholson, stands charged in count 1 of the indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about the 10th day of October 2022 in Bexar County, Texas. The defendant, Dominique Nicholson, is charged in count 2 of the indictment with the offense of unlawful possession of a firearm alleged to have been committed on or about the 10th day of October 2022 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the offense. 2, Section 46.02A1 of the Texas Penal Code provides that a person who has been convicted of a felony commits the offense of unlawful possession of a firearm if he possesses a firearm after conviction and before the 5th anniversary of the person's release from confinement following conviction of the felony, or the person's release from supervision under community supervision, parole, or mandatory supervision, whichever date is later. 3, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Handgun means any firearm that is designed, made, or adapted to be fired with one hand. Possession means actual care, custody, control, or management. 4, with respect to the evidence admitted in this case concerning the defendant having been previously convicted of a felony, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant was in possession of a firearm on or about the 10th day of October 2022. 5, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards the substantial and unjustifiable risks that the circumstances exist or the result will occur. The risks must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6, count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 10th day of October 2022 in Bexar County, Texas, the defendant, Dominique Nicholson, did use or exhibit a deadly weapon, namely a firearm, and Dominique Nicholson did intentionally or knowingly threaten imminent bodily injury to Jayla Satterwhite by shooting at or in the direction of Jayla Satterwhite with said deadly weapon, then you will find the defendant, Dominique Nicholson, guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider the lesser included offense of misdemeanor deadly conduct as instructed in paragraph 7, but instead proceed to paragraph 8 to consider count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Dominique Nicholson, not guilty of the charged offense of aggravated assault with a deadly weapon, and proceed to paragraph 7 to next consider whether the defendant is not guilty or guilty of the lesser included offense of misdemeanor deadly conduct. 7, lesser included offense of misdemeanor deadly conduct. Our law provides that a person commits the offense of misdemeanor deadly conduct if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. The applicable terms defined in paragraph 3 and 5 apply and have the same meaning here. With regard to the offense of misdemeanor deadly conduct, recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. You are instructed in this regard as follows. A, that the facts giving rise to this presumption must be proven beyond a reasonable doubt. B, that if such facts are proven beyond a reasonable doubt, you may find that the element of the offense sought to presume exists, but you are not bound to so find. C, that even though you find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense of misdemeanor deadly conduct. And D, if you have a reasonable doubt as to the existence of the fact or facts giving rise to the presumption fails and you shall not consider the presumption for any purpose. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 10th day of October 2022 in Bexar County, Texas, the defendant, Dominique Nicholson, did recklessly engage in conduct that placed another, namely Jayla Satterwhite, in imminent danger of serious bodily injury, then you will find the defendant guilty of the lesser included offense of misdemeanor deadly conduct under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Dominique Nicholson, not guilty of the lesser included offense of misdemeanor deadly conduct under count 1. 8, count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 10th day of October 2022 in Bexar County, Texas, the defendant, Dominique Nicholson, did then and there intentionally, knowingly, or recklessly possess a firearm, namely, Dominique Nicholson did carry a firearm on or about his own person, and Dominique Nicholson was prohibited from possessing a firearm under section 46.04A of the Texas Penal Code, and that the time of the commission of the charge offense, Dominique Nicholson had been previously convicted of the felony offense of assault, family, household member impeding breath or circulation on the 29th of January, 2013, and cause number D1DC1290440 and the 427th District Court of Travis County, Texas, and Dominique Nicholson's possession of the firearm occurred before the 5th anniversary of Dominique Nicholson's release from confinement or from supervision under community supervision, or from supervision under parole, or from supervision under mandatory supervision following conviction of the felony, then you will find the defendant, Dominique Nicholson, guilty of the offense of unlawful possession of a firearm under section 46.04A1 of the Texas Penal Code as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. To ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or a witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and the responses from the witness as they came from the interpreter in the English language. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers intended by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court which is hearing given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty of the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to this case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
We are, Your Honor.
All right, you may proceed.
Thank you. Ladies and gentlemen, a few days ago, earlier this week, my partner came up and put on a presentation for you. And during that presentation, she told you that us as a state have to prove each element beyond a reasonable doubt. And that testimony is evidence. Now, this week, you've heard a lot of evidence over the last few days, and Judge just read out a very long document, very long wordy document. And I'm gonna look at page 5, starting at page 5. And that's where the counts begin. Now, when you look at the elements, I want you to think about what we've heard over the last couple of days. We've had, there are points that are not in contention. We've had multiple people testify to the date in Bexar County, right? We've had multiple people identify this defendant, Dominic Nicholson, as the one who was standing in the middle of the street with his arm raised. We have people to put a firearm in his hand, pointing at the car that Jayla testified that she was in. We have testimony saying that shots were heard, that projectiles were found in that car that Jayla was in. We had Investigator Guzman say that a firearm is a deadly weapon, right? All of these things, all of these exhibits that we put up for you are evidence. Now, like Judge said, not all of these elements are going to go, or not all of these exhibits are going to go back, only the ones that we've offered. But for count 2, felon in possession of a firearm, we had to prove that he had previously been convicted of felony. Right here, we have that for you, and we'll be going back. We have proven each element of this case. And in a few minutes, my partner is going to come back up and talk to you a little bit more about that. But I want y'all to just think about what you've heard and how that testimony goes to each element of this case. Your Honor, we reserve the rest of our time for rebuttal.
All right, defense.
Thank you, Your Honor. Thank you very much. Look, you cannot convict a man on this shoddy investigation. You can't do it. They did such a poor and inadequate job investigating this case. And that gives you reasons to doubt You are not going back there to deliberate on this. You're going back there to deliberate on whether the state proved their case beyond a reasonable doubt. You are being asked to find a verdict of guilty or not guilty based on whether you think the state has proved each and every element beyond a reasonable doubt. And I would submit to you, they have not. And one thing we talked about in Fort Dyer, and boy, I'm glad I did mention it, is a 5 o'clock verdict. This is the worst possible situation I would like to find myself in, is actually at a 5 o'clock verdict. So I implore you, please, to give the case a time and effort and thought and consideration that it deserves, because so much is on the line. In Fort Dyer too, we talked about, I asked, what do you think is like some of the least reliable evidence? And someone said, eyewitness testimony. Least reliable. But let's look at the evidence that's not here, that they just do not have, which is no shell casings that were at the scene, no gun, and no GSR. And they're going to come up here and tell you it ain't no big deal because it could be or couldn't be. You know, I think the French is comme ci, comme ça, something like that. But it is important. Why did they take it? Why did they take it? Conduct the GSR kit? Because law enforcement believes it has evidentiary value, right? Why would they do it? They invest in the kit, they invest in the expert, and they do it because they believe it's going to produce evidence of value in a criminal prosecution, right? And guess what? In this case, it did produce evidence, and that evidence is there was no GSR on his hands, right? And that I asked Shep, I said, your conclusion is it's indeterminate whether he handled discharge, was in the proximity, right? That's her conclusion, that it was indeterminate. But the fact was, it's not there. He was negative for GSR. And that is a reason to doubt. And that's a biggie. That's a biggie. And you'll know because they're going to come in and try to minimize and undermine that point. But it's a big, look, they come to the house with a search warrant, right? They have a lot of law enforcement on the scene. They come to the house with a search warrant. Knock, knock, knock. We have a search warrant. Move over. We're searching your house. And they did. They had, maybe 4 or 5 officers inside that house, up and down for hours. They did not find a gun in that house. There is no gun, there is no GSR, and there's no testimony from any witness that says they saw him shoot. No one saw him shoot. They saw him out there, but they didn't see him shoot. And your job as jurors to decide guilt or innocence in this case is to decide, okay, maybe it is, maybe it isn't, maybe it probably is, right? But probably is not enough. Probably is not enough. It has to be more. It has to be beyond a reasonable doubt because we have life and liberty at stake here. I also think that you should be bothered by the fact that they did not investigate the other suspect. They tell you there's another suspect and they see multiple young men or gentlemen next door, right? They're outside who generally match his description. And guess what? We don't know their names. We don't know how to reach them. We don't know what they have to say. We don't know what their part is or whether they were out there, right? We don't know. We don't know. And that is a reason to doubt. That is a reason to doubt. You cannot allow the state and law enforcement to get away with a conviction based on evidence of this poor quality. Can't do it. And it's offensive, I think, for law enforcement to come upon a scene, get a few statements, decide that's the conclusion, and then let the rest of the investigation support that tunnel vision. That's kind of what happened. They go to the scene of the car, Conrad, or Jayla and Conrad are. They let Mr. Dorn leave with his vehicle. He removes the tire. The deputy says, yeah, I heard something inside the tire. He lets him take the tire with him. What? Take possession of the tire. Law enforcement's duty is to investigate and take tests and open, like, what? They let him leave with it? This is an alleged aggravated assault with a deadly weapon. 2 innocent people, and there's no evidence that they did anything wrong here. They were shot at. It's bad. We all agree that's bad. And they let him drive off. This car was the car that was shot at. And they let him leave with the tire. They let him leave with really important evidence. And now you're left with just crumbs of an investigation. And crumbs are not enough. Crumbs are not enough. I would submit to you that this is I call it a lovely neighborhood. I think everyone agreed with me. The houses are close together. And they not only searched the house, they not only searched the yard, they searched all the surrounding area, right? They didn't ask the neighbors who were standing outside whether they owned or possessed guns. I don't think they asked any questions to any of these people as to whether they owned or possessed guns. And so there is a whole nother part of this case that was not investigated. And we deserve that part of the investigation. I don't know what it would say. That's the point. That's the point. We don't know. And if we don't know, if we have a doubt, that's a not guilty. That's a not guilty. There are several different counts in the indictment. One of them being felon in possession of firearm. And you see a judgment here for a prior felony. And one of the things I ask you to remember when you deliberate is the constitutional principles that are at play here. And there are many of them in this jury instruction. The Fifth Amendment right to remain silent, right? The Fifth, Sixth Amendment rights to a fair trial, to due process, to the state proving it. Prove it. And they did not. The right to bear arms. These are important constitutional rights, and they're in play in this case. And I ask you to please remember them when you deliberate. I'm not asking you to like Dominic Nicholson one way or another. I'm asking you to consider the law, the Constitution, and whether the state has met the burden. It's a tough job that jurors have. This is a tough job because sometimes you're tasked with making decisions, hard decisions, I'll put that. You're tasked with making hard decisions. And we thank you for your willingness to serve here. And we appreciate and understand the depth and magnitude of what you're asked to do here. And there were a couple things I also was going to point out.
5 minutes.
Okay, thank you, Judge. Mr. Melendez didn't call, look at all the witnesses who didn't call 911. That's, I also find sort of interesting. And one of the 911 callers hung up on the operator. And I don't like, the citizen who calls 911 tells the 911 operator, I don't like your attitude. Bam. Bam. So what was really going on there, and how much were the neighbors concerned? I mean, Melendez didn't turn around and drive the other way. He went home. He says we saw a guy shooting in his street, and he goes home. He goes home and stays there. They all do. They all do. Jairus, very nice young man. I think his testimony was a little inconsistent, and he told you, I looked out the window, but I didn't see the shoot. And he only looked out the window for a very brief number of seconds. Jayla, lovely young girl, didn't see the shoot. She didn't see it. And when it happened, she's in the shock of what is happening. Can you rely on the testimony or the identification made in that moment of fear and shock and doubt, and I'm afraid for my life, right? And again, we don't know anything about the neighbors, and she said, no, I wasn't dating any of them. And I have no reason to not to disbelieve that at all. But we also don't know if they were in love with her, right? But she's beautiful. She's beautiful. And so, you know, there's just way too much out there that is uninvestigated and too many question marks, and it's just not enough. And even if you think maybe, probably, that's not what we're doing. We're protecting the rights of a citizen. We're protecting the rights, and we're making the government do their job. Do it and do it well. You're going to charge someone with a second-degree felony. Do your job. Be thorough. Exclude other suspects. You have another suspect, exclude him. So we don't have to have this kind of argument. But they did not. They did not. And I ask you to please go back there. Take your time, please. Deliberate carefully. Consider the constitutional rights that are at stake here, and find Mr. Nicholson not guilty.
State,
Yes, sir.
you have 12 minutes.
Thank you, Judge. What do we do when we've done something wrong to someone? What should we do? Apologize, right? I'm sorry. I'm sorry. To his neighbor, what? To Jairus, I'm so sorry. I'm so sorry. I didn't know it was her in the car. Not that he didn't know. He wasn't shooting at the car. He didn't know, presumably, or care who he was shooting at. I'm sorry, Jayla. To Jayla. I didn't know. I'll get rid of all my guns. Promise. The defendant is acknowledging what he's doing because he's apologizing for it. He knows what he did. We know what he did because Jayla came in and told you. Want to address some things stated by the defense counsel. She talked about a shoddy investigation. Jayla is not a part of or in charge of the investigation. She doesn't pick which officers go out to the scene and what they do. She was in a position where she needed police help and she called for it, or people called for her. And she is here today and yesterday to tell you what happened to her. Defense counsel talked about eyewitness testimony being unreliable. And I want to direct your attention back to jury selection just a couple days ago. She tried to say the same thing. But if you'll remember, juror number 15, who was sitting right up there, what eyewitness testimony would be reliable? Family members. You see them every day. Okay, you know who they are. You're not going to mistake them. And I believe juror number 11 up here said, even if a gun is pointed in your face, you're still going to know who your family member is. Juror number 2, who is sitting over here, multiple witnesses would make that less unreliable, right? More reliable. You had multiple witnesses, that would make eyewitness testimony more reliable. Well, ladies and gentlemen, we have 3 witnesses who put the gun in the defendant's hand as his hand is raised. Okay. Defense wanted to talk about no one saw him actually shooting the gun. We're talking about seconds. If you'll remember to yesterday, Jayla told you she heard the pop, immediately turned around and saw the defendant with the gun in his hand, standing behind the door. And then he got out, or walked around and walked towards her. She ducked down. 1, maybe 2 seconds went by and she heard more pops. Not to mention, Jairus said that he heard the gunshots, pop, 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 pop. 1 to 2 seconds later, looked out his window, saw the defendant with the gun raised in his hand. Juan is stopped at the stop sign right there, hears the pops, looks over and sees the defendant with the gun in his hands. We know the defendant shot at Jayla's car, or the car she was in, because there are bullet projectiles in the tire and in the car, in the back taillight of the car. Ladies and gentlemen, there is no doubt in this case. Defense also wanted to talk about there being no shell casings, no gun, and no GSR. And she also wanted to talk about the other suspect. But I want to make absolutely clear, because we tried to do this with Investigator Guzman. That other suspect, and I told you in opening statements, that other suspect has nothing to do with this aggravated assault committed against Jayla. That other suspect, as Investigator Guzman told you, was for picking up the shell casings. Why did they find those shell casings? Did someone pick them up? They were looking for a guy in white, if you remember what Investigator Guzman was telling them. And I'll direct you to State's Exhibit 5, I believe, where we have the next door neighbor's house. Who was there? But a guy in white. The next door neighbors that Jayla and the defense attorney, through her questioning of Jayla, told you the defendant parties with all the time in their garage. They are friends. Okay? There's also the defect in the fence behind.
That's a statement.
All right, ladies and gentlemen, you will remember the evidence as you received it from the witnesses.
You'll also hear from you also see in State's Exhibit, what is the picture of the fence, the defect in the fence. You're gonna see that defect in the fence. And Investigator Guzman told you that was concerning because a gun could fit through that. Now you may be asking yourself, did he have enough time to do this? Well, Deputy Rodriguez told you it took her 4 minutes to get to the scene. But if you'll remember Jairus from yesterday, he told you that he was outside talking to Deputy Rodriguez or whoever was taking his statement for about 10 to 20 minutes before the defendant came outside. We also know from Deputy J. Rodriguez that when he saw the defendant, he was changing shirts. Okay. This all points to the defendant having enough time to do what he wanted with the weapon. I want to direct your attention to the GSR. You heard from Ms. Shapey on Zoom, and she told you it is indeterminate in this case whether he handled, discharged, or was in close proximity to a firearm. It's indeterminate because she doesn't know the facts of this case. She told you there are circumstances that can diminish the efficacy of the GSR test. For example, if you wash your hands, it's going to get rid of, or could get rid of the GSR. You think someone can wash their hands in 25 minutes? If you touch a bunch of surfaces, that could get rid of the GSR. Well, we already know the defendant's changing his shirt. Jayla and Juan saw him in a black shirt when he had the gun in his hand outside, and Jay Rodriguez sees him in a blue shirt coming down the stairs. Maybe that's why there's no gun, no GSR, and no shell casings. Ladies and gentlemen, Jayla does not pick her investigators. I don't. It is up to you to determine if there was a shoddy investigation and how much that matters to you. But some facts, regardless of the investigation, don't change. And that's going to be the testimony from Jayla, Juan, and Jairus. Jayla was just trying to get to work that day. She's 18 years old, has an Ulta, she's Ulta badge, she's all done up, ready to go to work at Ulta. And she gets shot at by her stepdad. She's so terrified in that moment of maybe being killed, of getting hurt, that she ducks down and urinates on herself in the back of some guy's car that she just met a minute ago, not even. That is traumatizing. Yet she was still able to come up here and testify to you exactly what happened, answered every one of my questions, answered every one of defense counsel's questions. Jairus, he was 16 years old at the time of this offense. 2 years later, he's still able to come up here and talk to you and answer everyone's questions. Defense counsel mentioned something about inconsistent statements. It's up to you if you remember that, but keep in mind that you can only consider the evidence that is introduced to you. And if there's no evidence of inconsistent statements, there's no evidence of inconsistent statements. I submit to you that there is not. The facts in this case are simple. Jayla went out and got inside an Uber. She put on her seatbelt. She heard a shot. She turned around, saw the defendant, the gun in his hand. Then she sees him starting to walk forward towards her. Here, ducks down, hears multiple shots, 1 to 2 seconds later. The bullet fragments are in the car. That is aggravated assault with a deadly weapon. She was threatened of imminent bodily injury by this defendant. I do want to briefly talk about count 2, which is felon in possession of a firearm. As my partner said, you will have that judgment back there with you.
And 2 minutes, sorry.
One part of that is that we have to prove that the offense happened before the 5th anniversary of his release from confinement, supervision, or parole, or probation. Okay. That judgment will show you that he was convicted in 2013 and sentenced to 6 years. That means at the end of 6 years is 2019. This offense was committed in 2022. That is within the 5-year time frame. Ladies and gentlemen, I want you to think about when you're fighting at home with a loved one or a spouse, you know how hard it is to apologize to that person, even when you're looking them in the face and you know that they are right. It's hard to get those words out. You know when it's not? When you really know that you have messed up. When you have shot at your stepdaughter and a random person that you don't even know, when they have done nothing to deserve that. That's when you go around screaming to everybody that you're sorry. And that's exactly what he did. He's apologizing because he knows what he did was wrong, and there are consequences when we commit wrong actions. Defense counsel talked about life and liberty. What about Jayla's rights of life and liberty to live her life, to not be afraid in her life of being shot?
All right, that will be overruled.
To live her life, to not be afraid of not getting shot, to have the freedom, the liberty to be in her front yard, on her street in front of her house without being shot. Her life and liberty matters too. And we are going to ask you that you hold the defendant responsible in this case and find him guilty of aggravated assault, deadly weapon, and felon in possession of a firearm.
All right.
I'm sorry.
All right.
Did I
You
stop
have
a
10
little bit time?
seconds.
All right, 10 seconds. You do not even consider the lesser included offense unless you don't think the defendant is guilty of aggravated assault, deadly weapon. If you find him guilty of that, you do not consider the lesser included offense.
All right, ladies and gentlemen,